Heterogeneity is inherent in that.
Actually, the homogeneous nature of all the entries is for the purpose of designation.
Yes, absolutely.
They are homogeneous in the sense that each one of them is a scheduled caste. But your argument is that there is no homogeneity either in terms of the sociological profile, economic development,
Correct.
social advancement,
Absolutely.
educational advancement.
Absolutely. So that assumption in Chandriya was wrong.
Common factor is social and social backwardness, social and economic backwardness. But the degree may vary from one entity to another entity.
Absolutely. So the assumption of homogeneity in Chennaiya itself is constitutionally flawed. That's the first mistake Chennaiya made. The second mistake Chennaiya made was that it correlated the presidential order with reservation. These are the two assumptions on the basis of which Chennaiya was rendered. Neither of these assumptions is valid.
Because the designation is for the purposes of the Constitution.
That's correct.
It's not only for reservation, nor is it coterminous with reservation.
I'll go a step further. It has nothing to do with reservation. Well, that's the designation of this class has nothing to do with reservation. Reservation emanates from the plenary power of Parliament, which is in 16(4) for the purposes of employment.
Because Indra Swani says that it can be done even by executive instructions.
But now not anymore, Malaj. Because now it's Parliament has to make a law, Malaj.
What?
Now Parliament has to make a law to change the schedule,
Reservation, Indra Swani goes on to say that it is not necessary that there has to be legislation. It can be done even by executive instructions.
Maybe so, Malaj. But that is not part of the notification. But that's nothing to do with reservation. My point is, Malaj, you are assuming
that may not be correct, because if there is a reservation for scheduled caste, so unless that particular entry finds in the place in the presidential order, that person from that entry is not entitled to
I just demonstrate that, your lordships, wherever they wanted to give reservation, they have given it. Then reservation is part of 16(4) itself as far as employment is concerned.
It's a necessary but not a sufficient condition.
Correct.
Designation under Article 341 is a necessary condition for reservation, but it is not sufficient in itself. Correct. Because having been designated, there is still an enabling power which is conferred upon the Parliament, or for that matter, as brother says, on the executive.
Yes, but it's the Union or the Parliament, Malaj, but the order itself has no reference to reservation, and I'll show that from the chapter itself. Malaj, first of all, let me go to the first point, and then I'll come to the second point. These are two assumptions I want to deal with immediately. Now, kindly come to PDF. This is volume 4, PDF page 1381. Oh, sorry, 1386. The running page is 1381, volume 4. I'll quickly, Malaj, demonstrate that here also.
Page 1384.
Malaj, sorry. 1386, volume 4. My lord has it? Your ladyship has it? Just 4 minutes, volume 4. Or 10. So volume 4, page 1386, PDF 1386. Looking at Punjab,
Mr. Kassabel, just give me just a second.
What's your that?
Just one.
Sorry.
Volume 4, right?
Yes, volume 4, 1386.
Yes.
You have that chart now, Millet?
Yes.
Now kindly look at item 38 on the right-hand side.
Yes.
Mochi. We all know, Millet?
Yes.
Now look at 34. Sapera. Sapela means
snakes.
Snakes. One has nothing to do with the other. Look at Millet's Bazigar. He indulges in acrobatic feats. Then Batwal Millet. Actually belongs to the Rajput caste. Millet is normally a watchman. So what you have an agglomeration of various castes which are put together who have been humiliated for centuries. The heterogeneity is clear from the table itself. I can go on, Millet. There is one Gagra which has only 268 families in Jagraon in Ludhiana. There is a nut which is an unskilled labor. The Koli is the hunter and a butcher. The Sasi Millets is a criminal, comes from that class.
Kori would be fishermen.
No, but originally came as hunters and butchers. This item Millets.
So there is heterogeneity in terms of the pre-existing occupation.
That's right.
In terms of the resources or lack of resources.
Exactly.
In terms, therefore, of all the indicators of backwardness or development.
Exactly. So therefore, they are put in one class.
Income, social status. Yeah. The status of every caste may not be the same in the social hierarchy as well.
Exactly. So that
between them, some may be a little more advanced, some may be a little less advanced, people may be particularly underprivileged.
Correct. Absolutely.
In terms of other indicators like infant mortality, maternal mortality, fertility rates, which sort of define, broadly speaking, whether there has been progress in the social indicators.
Absolutely. Now that assumption was made by a observation of Justice Krishna Iyer in Thomas. And that's at page 135. Sorry, para 135, but let me give you the page. Volume 5. Page 84. ADF 84. Yes.
Did Justice Krishna use the word homogeneity or?
No, he said, he doesn't use the word homogeneity at all, Malat. I tell you, Lordship, what he said. Just have a look at volume 5, PDF 84. And this is, Malat, in fact, quoted by Justice Hegde. And then he comes to the conclusion that they are one class. Now just see, Malat, that. May I read it, Malas?
Yes.
We may clear the clog of Article 16.2 as it stems from a confusion about caste in the terminology of scheduled castes and scheduled tribes. This latter expression has been defined in 341 and 342. A bare reading brings out the quintessential concept that they, brackets, there, are no castes in the Hindu fold, but an amalgamation of castes, races, groups, tribes, communities, or parts thereof found on investigation to be the lowliest and in the need of massive state aid and notified as such by the president. To confuse this backwardmost social composition with caste is to commit a constitutional error, misled by a compendious appellation. So that to protect Harijans is not to produce prejudice any caste, but to promote citizen solidarity.
In fact, by using the expression, this mixed bag,
Yes.
the learned judge is really underscoring the heterogeneity of the
Exactly, exactly.
Then in the latter part, he says, but as a large backward group,
That's correct.
deserving of societal compassion.
Correct. Now, this is quoted by Justice Hegde and comes to the conclusion that it forms a class. Now, kindly have a look at that. PDF 796, Volume 5.
It's 796.
Yes, Volume 5.
Para
23. This is where the judgment 22 also is erroneous.
The way of doing it is that not to deny that they form a class, but they form a class for the purpose of Article 341.
That's right. That's right. Absolutely.
So they may be a class for certain purposes, they may not be a class for all purposes.
That's correct.
Basically what you said in your submission.
There is a level of, what should I say, Mother, discrimination which runs through this entire list. But their vocations may be different, their historical, the way they were treated may be different. There may be so many differences. The numbers may be different. The extent of discrimination also may be different. Level of discrimination may be different. For example, Malas, what we are dealing with are Majbi Sikhs and Dalit Sikhs, Malas. Now, do you know what the origin of this is? The origin of this, what is the origin of Majbi Sikhs? Guru Tegh Bahadur Malas, his body was mutilated. And he brought that body to Guru Gobind Singh. And he was a chamar. The person who brought that body was a chamar. So Guru Gobind Singh took him in his fold. And therefore the chamars became part of the Sikh community. Now what has that got to do with this list? That's the historical context. Yes, Mazhabi means faithful.
There is also an entry with regard to chamars.
Yes.
In Punjab.
That's right. And that's why, Malas, your lordships find that the 32% of the population of Punjab,
Completely.
32% of the population is Dalits. More than any other state in this country. Sweeper. He was a Chuda. He was a sweeper.
Pishti.
Whatever.
He was a Pishti. One who, yes, water. He was
Water.
a Pishti.
There are others also. In the list also there are lots of, anyway.
That happened, my lord, near Chandni Chowk. The incident.
Yes, of course.
Uh,
I'm quite familiar with it.
which is that? Gurdwara is there.
Now, let's just come to, this volume, PDF 796 of the same volume, paragraph 23, where he quotes, the learned judge quotes Justice Krishna Iyer. That's the 135 that I read to your lordship.
Para?
135.
No, para 23, where he quotes
Paragraph
135, which I've read to your lordships. And then he says in para 24, the learned judge, according to Justice Krishna Iyer, though there are no castes, races, groups, tribes, communities, or parts thereof in Hinduism, the president, on investigation, having found some of the communities within the amalgam as being lowliest and in need of massive state aid, including them in one class called the scheduled caste. The secretary thereof is that the scheduled castes are one class for the purposes of the Constitution. One has nothing. That conclusion is ex facie wrong. So I've demonstrated heterogeneity. I've demonstrated, Mullahs, that the basis of the judgment is that there is homogeneity. That assumption is wrong. And on that ground alone, Mullahs, the judgments must go.
Yes.
Now, sorry. Yes. So, Malad, therefore, now if you read 341 now with me, Malad, your lordships will realize, Malad, that in fact what Justice Krishna is saying is consistent with 341 itself. Kindly read 341.
I have to say that observation that amounts to tinkering with the president list in the presidential order, that doesn't appear to be, because
Absolutely.
they don't say that if you remove comma or
Absolutely.
Nor are they saying that this particular caste is a synonym of whatever is a designated caste. That include therefore this caste. Not is the state of Punjab arguing it, that though these castes have been not designated, these particular castes are also are synonyms or belong to the same. That you can't do. That even we can't do as
Exactly.
beyond the power.
Exactly. Now, if you read 341 with me, Malad.
341.
Yes. The president may, with respect to any state or union territory, and where it is a state, after consultation with the governor thereof, by public notification, specify the castes, races, or tribes, or parts of or groups within castes, races, or tribes, which shall, for the purposes of the Constitution, be deemed to be scheduled castes in relation to that state or union territory, as the case may be. Heterogeneity is writ large in 341 itself.
Anything else on the first point?
Well, just one point. Your lordship asked the question why the word deemed is there.
Right.
Because I just wanted to answer that, because that is there because
that's the learned AG wanted to know.
Because, Malaj, it can't be changed till Parliament changes it. It's deemed to be. Nobody can tinker with it. That's the reason why deemed is there. Because 2 says Parliament may by law include or exclude. till such time as Parliament passes, it's deemed to be. No state government, no central government can tinker with it after the presidential order. So that, just to answer that question that arose. Now, let's come to the second point that I was arguing.
Yes.
Namely, that this has nothing to do with reservation. Now, kindly come, brothers, with the greatest respect, kindly come to the chapter, how it starts. Special provisions relating to certain classes. That's chapter, part 16. Now, your lordships will find in this chapter, wherever the Constitution wanted to provide reservations, it said so. I'm not saying that the union government cannot ensure that there are, that's not the point, Mullah. That power the union has, that power Parliament has, that's not an issue.
16.4 doesn't refer to reservation.
16.4 does. I'll show, Manoj. That also is a misreading of 16.4. I'll show that presently, Manoj. Just allow me to take this.
330 expressly says reservation.
Yes. Reservation of seats for scheduled castes, scheduled tribes in the House of the People. Kindly come to 331, 333, 2. Reservation of seats for scheduled in the Legislative Assembly. Then come, Manoj, to 334, reservation of seats and special representation to cease after certain period. 335, claims of scheduled castes and scheduled to services and posts. And then, Malas, your lordship comes to the National Commission for Scheduled Castes, which is 338, which, Malas, does this exercise. Because that recommendation is sent to Parliament. Parliament then decides whether to exclude or include. That applies thereafter to National Commission for Scheduled Tribes. And then your lordships will see for the backward classes, 338, 38B. And then you come to Scheduled Caste 341. So the scheme of the Constitution is clear. 341 is meant to identify the heterogeneity of those communities and castes and tribes who have been dehumanized over centuries. The power of reservation, your lordships will find in 16.4.
Mr. Sibal, in any state, is there any reservation under Article 330 specifying the communities which have been included in the scheduled caste based upon their population ratio or something like that? No.
No, I don't think so.
Like Valmiki's 5 seats
No.
out of total of 100 seats,
No,
supposing
no,
coming
no.
for.
So in Parliament, it's only for either scheduled caste or scheduled tribe.
That's all. That's all.
But then there can also be cluster classification in that also.
No, there's.
There is none. There should not be either, Malas.
Why?
For the simple reason, Malas, the representation of the caste to take forward.
I
the
think as a matter of fact,
Yes,
insofar as parliamentary elections are concerned, even a scheduled caste from Punjab can contest in Maharashtra
that's correct.
against the scheduled caste.
That's correct. That's correct. Because when we're talking of reservations, we are talking about education and employment, not representation. No, quick classes, quick different. Your lordship is right, but the problem there is, they can contest, each one of them.
Reservation for appointment is.
No, they can contest, Malaj. They're not prohibited from contesting. So that's what the privilege is only to contest. That's the reason why.
a higher population will always succeed.
That's true. That may be true.
Of a community which has very little.
Hopefully, Mother, that situation will not
That-
rise that we.
Therefore, there was a debate
Yes,
in the constitution because Dr. Ambedkar, prior to Pune Pact,
absolutely.
he wanted resorts specifically.
That's right.
Then ultimately Gandhiji went on a hunger strike and
Reserved.
Therefore, it was
and
reversed.
elected.
It was reversed.
And electorate.
Yes, it was reversed. So if you look at 16, Malad, something very interesting emerges. First of all, Malad, let me tell you, Lordship, the difference between 15.4 and 16. Kindly read 15.4 with me. You will find no mention
Reservations.
of reservation.
It's special measures.
Special measures for advancement. This is important.
That's right.
Nothing in article, Malad, let me read the whole. The state shall not discriminate against any citizen on grounds of religion, caste, sex, etc. No citizen shall on grounds of religion, caste, race, caste, sex, place of birth, or any, have, with regard to access to shops, public restaurants, hotels, places of public entertainment, or the use of wells, tanks, bathing ghats, roads, places of. Now, Malad, these special provisions under 341 can relate to this.
That's what the learned AJ argued, that and Mr. Farasat also, that Chennai, they failed to consider interplay between 341 and 16.4.
But I'm not on 16.4. In fact, I'm going to make a distinction between 15.4 and 16.
But 15.4 may also comprehend reservations as well.
It does, Malaz, it
But
does.
the
It
concept of special provisions for advancement
would
is
include.
broader than just reservation.
I agree, but I'm just only saying
Reservation
advancement.
postulates a quota, while a special provision may be
Yes.
quota plus. It
Exactly.
could be relaxation,
Exactly. In other
scholarships,
words,
anything.
The reason why I'm saying this, the reason why.
15.4 was brought because it was held by this court that there can't be a reservation.
That's right.
In 51,
That's
They struck down community-based reservation.
You are-
Champakam Durai Rajan.
Champakam Durai Rajan.
Malaz, there's a reason why I'm making this submission, Malaz, for your lordships to consider, Malaz, and that is, there is a symbiotic relationship between 15 and 16. You
There is a
reach
Symbiotic relation.
you reach 16 only when you are empowered under 15. If you're not educated, you can't get employment. It's simple as that. No,
For a member of parliament, there is no
I'm
qualification.
I'm talking about in the larger context, Malas. We're talking about 21st century, Malas. We're talking about the 21st century, Malas. Of course, some of them can,
The same
Some
school,
of us-
14, 15, 16.
some of us can hold the highest positions in the country without being, so that's another matter, Malas. Some of us, Malas, have reached corporations, Malas, and to manage corporations without necessarily being fully educated. That's not the point. The point is, Malas, there is when you're talking about this section of society, there's a symbiotic relationship.
So we must recognize that the constitution is not prescribing qualifications such as property, education, gender. This was an article of faith.
Yes.
And it was a very visionary provision because ours was one of the first constitutions which did not make your right to contest an election or to hold electoral
Yeah, I
office
agree.
conditional on
I agree entirely. And it's a
conditional on
statutory
gender or property or
provision.
your educational qualification.
I'm with you on that, Malas. I'm arguing something different. What I'm saying is if this class of people that you call a class, if you don't empower them under 15, you're not going to get representation under 16.
So in that sense, 15, as you said, they share a symbiotic relationship because unless you create the foundation for employment,
Right.
you not get employment.
That's-
You need a qualified workforce to be
It's only in that
in the
limited,
workforce in the first place.
it's in that limited sense that I'm talking about this. Well, that's all, nothing more than that. Nothing more than that. Now, if you look at 16.4 now, in this context, it doesn't also talk about Malay scheduled caste, scheduled tribes. But if you go to 16.4A, it talks of scheduled caste, scheduled tribes.
The judgment of this court.
That's right. So if you are not included in 16.4, how do you get Malad's, reservation and promotions? 16.4 has to include scheduled caste, scheduled tribes because they are backward. They come within the genus of backwardness. So 16.4 is an answer, 4A is an answer that 16.4 includes. Yes. In the volume 4A, Manoj, that I have uploaded, 4C. 4C, no, 4C. Yes, just see, Manoj, I've given to your lordships in volume 4C, page 13. PDF 13. There are various acts that have been passed, which is why 341 and 15.4 allows for advancement through various legislative or executive measures.
The reservation could be one of them.
Yes, reservation is one of them. And it's integral. I'm not
The
saying
universe is much wider.
much wider. So therefore, I've given some of the, you have the Karnataka Scheduled Caste, Scheduled Tribe Prohibition of Transfer of Certain Lands Amendment Act. You have Scheduled Caste, Scheduled Tribe Prevention of Atrocities Act. There are all kinds of. You have the Protection of Civil Rights Act of 1955, all kinds. So, Mullahs, therefore, I just wanted to, and Mullahs, when we look at reservations, this will never end. This is an unending exercise that we are going through as a nation. The reason is very simple, Mullahs, that unless 15.4, unless you advance under 15.4, you'll not go to 16.4. So if you look at Mullahs Punjab, and I'm not going to the numericals of it, but the fact of the matter is that the total population of these is about 280,000. Government post is 280,000, approximately. I'm just giving your lordships.
Of Mazhabi Sikhs.
No, total government posts. The Mazhabi Sikhs and Dalits are about 32 lakhs. Total number of posts are 280,000. Out of that, Mullahs, 25,000 goes to scheduled. 25% goes to these classes, backward classes. Of the 25%, 50% comes to Mazhabi and Dalits.
Mazhabi and Valmiki.
And Valmikis. 50% come to Valmikis. And I am told, Mullahs, how many seats have been actually? Total. Most of them are not occupied even.
And it's preferential, so it goes to anybody else.
Yes,
then.
and
Don't
it will
carry
go to
forward.
anybody else. Most of them are not even occupied. What does that tell you? What does that tell you? And that's very important. I want your lordships to actually mention it.
That posts are not unoccupied.
Well, they will give you the data. Actually, I've asked the state.
Yeah, maybe there is no adequate representation insofar as Mazhabi Sikhs and Valmikis are concerned.
No, the others also. In fact, I've got some data, but I've asked the state, they'll give you the data. I've asked by this evening, we'll get that data.
Therefore, your point that unless there is educational advancement under 15 and social advancement,
That's right.
16 remains teasing.
Dead letter. There'll be cases after cases on the same issue for times to come. And if you can have Kasturba Gandhi schools for girls, why can't you have schools for Mazhabi Sikhs or these communities? Not just for everybody. That's the way forward for the nation. You don't empower them, and then you keep on fighting that there are not enough people in promotion.
Right, yes, Mr.
Well, therefore, I beseech your lordships, but this is an area your lordships should say something.
Okay, anything further, Mr. Sibal, now?
Huh? Yes, now, well, that's just my written submissions, then I've done, because I don't want to take volume 1B, PDF page 29. Where is 1B? Yeah. So, well, I'm not going to, well, take your lordship because there's no time. Just come to the page 54, para 54, Malas. PDF 27. Just a quick look at that, Malas. The table, I'm going to show that table. Yes, your lordships will see that para 54, it's
PDF?
PDF
Page 27.
27. Running page 26. It says A, Malas, small paragraph A, a study of Punjab caste done in 1883 found Mazhabis belonged to the Chura caste and were primarily scavengers and sweepers. As per the report of the Evaluation Committee on Welfare regarding welfare of SC so and so, for the period commencing 15th August 47, dated 65 to 66, Mazhabis had a total population of 664,000, while Balmikis had a total population so and so. Said report also found the social conditions of scavengers were awfully deplorable. They didn't even have proper access to utensils, let alone housing. They had meager income, were forced to do scavenging despite working from dawn to dusk. The report also noted that educationally they were extremely backward, even more. The literacy rate is around 41%. Malas. So Malas, all I request your lordship is read through this, please, because I don't want to waste your time. This will tell you the situation that we are in. And I'm deeply obliged. I didn't want to repeat anything.
Thank you, Mr. Zulu. Thank you.
What?
Mr. Solicitor?
I'll take only 10.
We'll hear the solicitor so that.
No, Mr. Venugopal was on screen.
So Mr. Venugopal should argue
No,
first.
I'm sorry. He's
Well,
on
that's-
screen, he was supposed to go next, but he has said, there's been a bereavement in my family. So he has said that I could go before him. Both him and Mr. Nidesh Gupta have been kind enough to say that. I just wanted to inform you.
Certainly, you have to leave the
Because you
court.
have an order, that's why I want.
Certainly.
Malas, just one issue, Malas. Indira Sani, paragraph noted, Malas, please. PDF 689, paragraph 778.
Just one second.
Yes.
Sani, volume?
Volume 5, PGFK 689, paragraph 778, they explain as to why in 16.4 the word class is used and not caste. They explain. I just read it. Indeed, there is a very good reason why the Constitution could not have used the expression caste or caste in 16.4, and why the word class was a natural choice in the context. The Constitution was meant for the entire country and for all time to come. Non-Hindu religions like Islam, Christianity, and Sikh did not recognize caste as such, though, as pointed out herein above, caste did exist even among those religions on various degrees. Further, a constitution is supposed to be a permanent document expected to last several centuries. It must surely have been envisaged that in future many classes may spring up answering the test of backwardness, requiring the protection of 16.4. It therefore follows that from the use of the word class in 16.4, it cannot be concluded anything else? So therefore, the judges say the word class in 64, in our opinion, is used in the sense of social class and not in the sense as
We'll have a look at
it's
it.
antithetical to
Thank you,
caste.
Mr.
I'm
Zulu.
deeply.
Mr.
It's
Shankar Narayan?
No, we can't. There's others have to also argue.
Sitter wanted to address your lordship, I think. he has
Mr. Attorney, Mr. Shankaran, there's been a bereavement in his family, so he has to leave. So can we hear him for 10 minutes or so, and then we will,
You didn't request me for that. Of course we can.
Well, may I be
Of
excused?
course we can.
Want to go? Just volume what? Hey, please, ma'am. May I just start with expressing my gratitude to all the seniors who should have gone before me, who have been kind enough to let me go before them. I'll just keep it very brief. There are just 4 points that I want to make. If your lordship would be kind enough to have volume 4B, B for Bombay.
What is the first point that you would make? So then we'll take it.
I'll address the 4 points. The 4 points are these. First, that in identifying the scheduled castes and scheduled tribes, a bit of a historical context is necessary, because eventually we're talking about how you will classify within these groups for the purpose of giving them measures. So the historical context will broadly show you how they first come to be identified. Why are they forever called scheduled castes? Where does that schedule come from? It comes from the Government of India Act 1935, and there's a background behind it. It starts with the census in 1891. I'll briefly touch upon that. All of that is in volume 4B. The second, this will also briefly touch upon that question that fell from the bench yesterday about why tribes, the word is used while defining scheduled castes.
In 341 also.
Yes. Why is it used there as well as in 366? In both places, scheduled castes are including tribes. Why does that happen? The second, Maloj, is that the constitution and its approach towards scheduled castes and scheduled tribes. You'll find that it was a very, very important and integral part of our constitution making, starting from the Pune Pact, starting from many other big leaders, both from the Dalit community and outside, who were responsible for ensuring that many provisions of the constitution were infused with this, with taking steps. Article 15, which has provisions which come from the Pune Pact, Article 17 and its abolition, exploitation provisions in 23. All of these, along with 15, 16, yes, of course, that's what we keep dealing with. But we must draw a small distinction between 15 and 16, which are provisions which are not automatic, which don't immediately give a right to a member of the backward community. It is for the state to make a law under 15, 16 if it so wishes. So 15, 16 are enabling provisions. 330, 332 and the provisions dealing with municipalities and panchayats give them a right. So how that started and that context under the constitution will perhaps help, I think, this bench in looking at the context in which we are arguing this case. Because in my view, at least my submission is that this subclassification is to be done at the end when the enabling provision is being activated. It is at that end that you decide while dealing only with 15, 16. That subclassification cannot be, and I think it came in the discussions earlier today, in 330, 332, etc. That can't be done. It's on 15 and 16.
Or the Panchayat Raj and
Yes,
municipalities.
or panchayats or municipalities. That's the second limb of the submission.
Yes.
The third, it's been touched upon by Mr. Sibal. I won't spend too much time on it. That error in Chinnaya, while looking at the Thomas paragraph of Justice Krishna, in fact, I'll make this point right away. It's just that this is an editorial intervention, an unnecessary editorial intervention in the SEC volume, which has caused this confusion. What exactly happened is in N.M. Thomas, Justice Krishnaiyer uses the word they, They. He uses that to refer to the various groups, etc., who are the Dalit community. He says that they aren't part of the Hindu groups. Unfortunately, when the editor published in SEC this judgment, within brackets, it put SIC, there, THEIR. Now that there is treated by Justice Hegde in Chennai to mean therefore a complete homogeneous group. They and there made a big difference. I'm just making this submission. The Lordship may see those two paragraphs, but I don't want to spend too much time on that.
Right.
And finally, there are a few questions that fell from your Lordships yesterday. I just want to address each of them. I think there were some doubts that your Lordships had. So I'll just do that briefly. If your Lordships, the first main limb is going to be the first two, 4B, volume 4B, B for Bombay, of the compilation. And I'll quickly go through that.
Editorial mistakes can sometimes cause very grave blunders.
Correct.
In fact, when we wrote I wrote the seven-judge judgment on the Arbitration Act.
Yes.
It was an editorial blunder in one of the private publications which was handed over to the bench.
Oh.
Which pointed out that a particular provision was brought into force when it was exactly to the contrary.
Oh, it wasn't brought into force. Well, that's very risky, Manoj. 7 judges we should.
And it was, so we noticed that and corrected the error in 7 judges.
Well, so if I can trouble your Lordships with volume 4B. 4B for bomb. I'm sorry. Yes.
What is the fourth? Volume 4B?
4B. B for Bombay.
This is your fourth point.
No, this is the volume for my first point. I'm just taking your Lordships to the compilation. Compilation, volume 4B.
Volume 4B.
Yes. Not right now. 4B, my lords, if your lordships will take the first page, that's the census report of 1891. Your lordships have that? Census, that's page 2 PDF as well as running page.
No.
No.
That is Dr. Ambedkar Foundation, that is writings and speeches.
Volume 4B for Bombay? 4B?
4B.
Dr. Asa Ambedkar writing and speeches, chronology of events.
Ask the Nodal Council.
No, I've been told.
No.
No, we have downloaded it as Roman. It's Roman 4B.
Roman 4B.
It's for others also. It's census report. I'm sure. Sorry if there's
Roman 4B.
Huh? The one your lordships are referring to is 4A.
4B.
Oh, 4B. Oh, I'm sorry. Then would your lordship check 4A? Because we have all been told that it's 4.
Also has some reference to Norway incident which Mr. Faraz yesterday mentioned.
Okay. So I'm sorry.
4A has Constituent Assembly debates, etc., etc. The Tyranny of Merit, Michael Sandel.
Let me check which volume this is.
Meritocracy Trap.
Huh? Could you
I can wait in.
just take it? 4C, 4D. Sorry. 4B. Oh, this is something else. What are you saying? No, let it be. I'll just address them. Look, it's filed the volume. The file the compilation. It's not there. But no, we checked with the nodal council. He said it's been uploaded. If it's not, I'll just anyway address your lordships. Then it's going. We'll go right now. Okay. But they're just uploading it. I'll just address your lordship. I don't want to take time. I'll just briefly tell your lordship what it is. There is an 1891 census report. It was the first census report. Now that census report went into a detailed enumeration. At that point of time, what they did is they went through occupations, because throughout the 19th century, the British had come up with many reformist processes from their end as far as the Hindu community largely was concerned. Your lordships know everything with reference to Bentinck's reforms, etc. But towards this end, they wanted to find out what the various occupations were, because they found that within the large Indian communities, you would not have intermarriage, you would have people living on the edges, not allowed to share water, not allowed to eat, etc. together. And they looked at the various occupations because many groups were being excluded completely from the occupations. So occupation-based census is this one of 1891. And this provides for the manner of the enumeration, the classification of the occupation, and they specifically say that with reference to these, what they came to refer to as depressed classes, that's the phrase that they used to use then until it was dropped in 1935, the depressed classes, they said that there were many, even within the Rajputs and the Jats, they didn't look at them as castes, they looked at them as tribes. That is where, my lords, this notion of tribes for the purposes of the depressed classes. We are not right now talking about the scheduled tribes, scheduled castes. With reference to them, they refer to them as tribes. And they mention community-wise the various groups which are dealt with, which includes 10 minutes. The various tribes. And they divide them into various classes. Class Roman 7. Class 7 are known as the menials. Those are the ones today who have been come to be described as the scheduled caste. This is stage 1, 1891. The next one is 1930, which is the Indian Statutory Commission, which goes in detail into these depressed classes. The phrase depressed classes eventually came from a report of 1918, which became a part of the Montague-Chelmsford reforms. But they refer to, they use the phrase, employing the phrase depressed classes. They look at these statistics from previously and say nearly 20% of the population belong to these classes. They say that these classes are partly functional and partly tribal, and they mention the various types of disabilities that these groups have been suffering over a period of time. The 1931 census is the third in this sequence. And it was carried out by a famous anthropologist at that time, Mr. Hutton. And he says, for the first time, he refers to primitive tribes. This is where the concept of scheduled tribes come in. They say that there are many tribes because the exploration of India for the British census takers was taking time. So they reached Nagaland, Arunachal, etc., and discovered many tribes which are nomadic or in jungles and forests, etc. And they refer to them as primitive tribes who haven't really come in contact too much with society. And they refer to them. 1931 is the first time that you find that there are these primitive tribes as well. This is for the purpose of the identification. And they shift in 1931 from depressed to referring to them as the ones formerly known as untouchables, and say that we shall refer to them as the scheduled caste. Now, the reason why scheduled caste is that in Government of India Act 1935, they eventually laid down that for representation in the federal legislature, there would be a first schedule to the Government of India Act, which would provide how the various communities were going to be represented. Now that, I think they're just transferring it. That is the one thing I'd like your lordships to see, because all these communities that you find, where did in 1950 did the president suddenly get this list? He got this list from the first schedule of the Government of India Act 1935.
Right.
And we continue to refer to it as scheduled caste and scheduled tribe because of the schedule in the 1935 Act, nothing to do with the Constitution itself.
Right.
It's come. Can your lordships now see it, Manoj? It's on screen.
Yes.
Yeah, I can see that. It's good. Just if I can trouble your lordship, I've told your lordships the first, that's the 1891 census report. Then the next is that statutory commission report. There are page numbers. I'll give that to you in a single note, my lords, because I want to keep it short. and then is the 1931 census, and then the Government of India Act 1935. If your lordships would be kind enough to come to page 58, that's where the
Why
act
didn't you do
starts.
this, Mr. Shankarnarayan?
Yes.
Today you have cleared the court, but you can add to your submissions
Yes.
just an addendum
Yes,
and make sure it goes into our copy.
I'll do that.
So that, then you can also, we label this particular compilation as volume whatever.
Yes,
You can give us a 2-page note
I'll
on
do-
the evolution.
I'll do that.
And I think that
this is why I'm trying to keep it short. I'll just highlight what I'm saying. Just for a minute, if I can trouble your lordships only with, of this volume, page 185. This is the first schedule. The lordships can see that. It's marked. It's the first schedule to the Government of India Act. And in this, my lords, entries 4, 8, 18, and 20. Your lordship may note that. Entry 4, for example, I'll just read to your lordships. To each governor's province, chief commissioner's province, and community specified in the first column of division 1 of the table, there shall be allotted the number of seats specified in the second column opposite to that province or community, and of the seats so allotted to a governor's province or a chief commissioner's province, the number.
Was the expression scheduled caste defined in the, and
It is defined. It is defined in 26. Yeah, but I'll just, 4, 8, 18, 20 refers to scheduled caste.
Yeah.
And 26 defines scheduled castes. So just, it's the exact same definition that you find now in the Constitution of India. 26, can they go down? Can you scroll down? 26. That's at page 189, PDF 189, the middle of 189. Yes, the scheduled caste means such castes, races, or tribes, or parts of or groups within castes, races, or tribes, being castes, races, tribes, parts, or groups which appear to His Majesty in council to correspond to the classes of persons formerly known as the depressed classes, as His Majesty in council may specify. So this is copy pasted effectively and put in the Constitution. Immediately after this is the scheduled caste order of 1936 by the King in Council, which is at page 253. It's very interesting. The previous year, 1935, Government of India Act is by George V. This is by Edward, who abdicated, as your lordships remember, because of that. So in the 1 year that he was king, page 253, this is issued, first paragraph, page 253. Whereas by certain provisions in the first, fifth, and sixth schedules to the Government of India Act, His Majesty in Council is empowered to specify the caste, race, or tribes, or parts of the groups within caste, race, or tribe, which are to be treated as the scheduled castes for the purpose of those schedules. And it's not only schedule 1, but other schedules as well, as you'll find from para 2 of this in the middle of the page. Subject to the provisions of the order for the purpose of so-and-so schedules, these are the ones who will be specified. Para 3 is interesting. It says, notwithstanding anything in the last preceding paragraph, no Indian Christian shall be deemed to be a member of the scheduled caste. No, in Bengal, no person who professes Buddhism or a tribal religion shall be deemed to be a member of the scheduled caste. This is after the partition of Bengal.
Yes.
And next page onwards are the castes. So these are the castes, tribes, all of them, state-wise, as per those states, Madras, etc. Now, this in its entirety, this goes on for several pages more. This in its entirety, community-wise, was what was replicated in the presidential order of 1950. The presidential order had to be amended a few times every time we had a reorganization of states, because it was unclear whether that community will remain an SC for that partitioned state or not. So they did, every time there was a reorganization in 56, 59, they did actually amend the presidential order of 1950. I'm quickly coming to my second limb. This is to give your lordships context and to say that these are the groups. Therefore, at a later stage, when you come to enabling provisions, when you decide to give those communities, if some of those communities have been, say, for 16, adequately represented, then it is incumbent on the state not to repetitively give them, who are adequately represented, that benefit. I think that point has already been made repeatedly. Second, I'm just handing this over. It's there in this volume as well. It's there in the volume, yeah? Just take 7 copies. This, my lords, is something I had submitted in the EWS reservation case, the 5 judges, just which has been included in the Janhit Abhiyan judgment, in fact. It's a chart showing reservation provisions under the Constitution. All the provisions are here, which are dealing with this, just to help address your lordships on It's in this also. It's at page 805 of this volume. It's at page 805, but I'm just addressing it from here, if I may. This is to show the provisions, Malons, which govern each of these communities. The central one, the red one, is SC/STs. The one outside that is SCBC, OBCs, and the one at the outermost is EWS. We can ignore EWS for the time being. SC/ST, the definition provisions are there. Then the special provisions are there. Now, why we have color coded it separately is for the parameter that has to be applied. The parameter that has to be applied for the scheduled castes and scheduled tribes with reference to 15 and 16 is historic untouchability. Because I think there has been a general sense that social and educational backwardness is the determinant for being an SC/ST. That's not true. For being an SC/ST, it is about its historical backwardness and it's a constitutional atonement for those years of discrimination. So for determining who the scheduled castes are, and this is what even the 5 judges decision in Mari Chandrasekhar says. Specific paragraph I'll give you, it's para 9 of Mari. Mari is, I'm sorry, it's not part of this volume, but the paragraph is extracted. It says that it's a historic untouchability which is for the determination of SCs. Social and educational backwardness, which is defined in the Constitution, in Article 366, says for the purposes of this Constitution, socially and educationally backward are those who are determined by way of the list which the President provides. But that came in by way of an amendment, that definition, because after the Indira Sawhney judgment, the Indira Sawhney judgment gave one direction to the government. It said that please ensure that you set up a national commission for the backward classes, and they set up a national commission. There was a National Commission of Backward Classes Act. Subsequently, when the Constitution came to be amended, that National Commission was taken and put on a constitutional plane, from statutory to constitutional. And therefore, the definition had to be given of who are socially and educationally backward classes. Now, there has been a little bit of debate in the past whether socially and educationally backward classes is the phrase used in 15. It's not used in 16. In 16, you say backward classes, which is why you get the O in the OBC. You have SCs, STs taken anyway to be backward classes for purpose of 16. Other backward classes are those outside of that. Are they the same as the SCBCs? The Constitution seems to suggest to us, courtesy all these amendments that have come, that they're perhaps the same. We don't have a fourth list of OBCs. We just have the SCBC list. That's the one that's adopted. But for determining the scheduled castes and scheduled tribes, it's historic discrimination. So that pink one shows that that's historic untouchability. Now, the reason why I put the blue ones, your lordships will see,
the political backward.
Political backward.
Political reservation.
So in municipalities and panchayats where you have these provisions, as well as in the Lok Sabha and the legislature, these are the political backwardness determinations that have to be made. The third, of course, are the social and educational backwardness, which are in yellow. Now, one small distinction, I think, which is essential for answering the question that has been referred to your lordships is simply this, that the idea in the Constitution at the time the Constitution came in, the SC/ST communities had only one provision of reservation to them, which are the ones in 330 and 332, nothing else. As a provision of reservation available to that community, it was only in the legislatures and parliament. Subsequently, when enabling provisions were activated from the outset, from Champakam and Venkatraman, both decided in 1950, or one on 15 and the other on 16, there was an activation of that. Even though the GO was prior to the Constitution, there was an activation of 15 and 16. Once you activate 15 and 16, does the state not have the right to say that, look, your list which the president has made, that remains intact. I'm not trifling with it. But for my purposes, where 15 and 16 gives me the right to make a measure, yes, I believe that these communities need to be favored. Now, whether the choice of those communities by me is right or wrong will be determined based on reports, based on other data. The Indira Sawhney judgment says use the barium chemicals, yes, measures to determine that. But that list remains intact for the purposes of the political representation. So for municipalities, panchayats, legislature, and Lok Sabha, I can't touch it. The state has absolutely no role to play in that. that remains. I hope I'm making myself
Yes.
clear. So that distinction is necessary. This entire debate here is really only about 15 and 16. Because the definitions, both in 340, 342, as well as in 341, 42, as well as in 366, make it clear for the purposes of this constitution. So the SC/ST determination or definition for the purposes of this constitution encompasses the mandatory political representation for which the state has no role to play at all. It can't interfere in any way. And where the state has a role to play. It's only in that where the state has a role to play under 15 and 16 that it is the entitlement. In fact, it's a constitutional obligation of the state to make such determinations. So this chart is for that purpose.
We got the point. Should be
Yes.
now closed.
The last thing is to address those questions. Well, one more. There's a judgment of your lordships, which is in this compilation at page 353, my lords. This is a small concept which may be relevant. This is a judgment of my lord, the Chief Justice and Justice Shah in 2021. This is at page 353.
Yes.
Patan Jamal Wali. It was dealing with the outrage, the rape of an SCST lady who was also blind. Now, two paragraphs, just see para 17 at page 372, internal 372, para 17.
Yes.
This principle of intersectionality, I comment to this bench. Intersectionality can be defined as a form of oppression that arises out of a combination of various oppressions, which together produce something unique and distinct from any one form of discrimination standing alone. While the model of intersectionality was initially developed to highlight the experiences of African American women, there is a growing recognition that an intersectional lens is useful for addressing the specific set of lived experience of those individuals who have faced violence and discrimination on multiple grounds. A single axis approach to violence and discrimination renders invisible such minority experiences within a broader group, since it formulates identity as totemic and homogeneous, which is precisely what Chinaya has done. Each of these communities have lived experiences which are distinct from each other. Even in Indrasani, I'll give you a lot of the paragraph, there is a acceptance. Justice Krishna and Anam Thomas says that even within the scheduled castes, they're not all alike. They're all very, very different. They have different experiences. But I won't read the rest of the paragraph, but I believe this paragraph
Yes.
and
Para.
para 795